My name is Sarah Murray, and I'd like to start by welcoming you all to the Law School at the University of Western Australia on behalf of the Public Policy Institute, the Law School and the Australian Association of Constitutional Law. And I'd also just like to give a special thanks to Dr. Rebecca Ray and Professor Shamit Shagar for organising and preparing everything for tonight's event. I'd like to acknowledge that the UWA campus that we're meeting on this evening is situated on Whadjuk Noongar land, and that the Whadjuk people of the Noongar Nation remain the spiritual and cultural custodians of their land and continue to practice their values, languages, beliefs and knowledge. I acknowledge their silenced voices, their untold stories and the strong call of the Uluru Statement from the Heart, and I pay my respects to their elders past, present and emerging. Tonight's seminar is set to be a very stimulating and provocative discussion about something that has really impacted us all in so many unexpected ways since the beginning of last year. The event is going to be live streamed, and we have a number of attendees joining us from not only around the country but also overseas, and they will also be able to participate in tonight's Q&A. We're going to start with an opening panel discussion, and then we're going to shift to an open Q&A with the audience. You'll be able to ask questions of the panelists, and those of you who are online will be able to ask questions using the Q&A function, and that will be facilitated through Rebecca. The event is being recorded, and a link to tonight's seminar will be circulated to you all in about a week's time when that recording has been arranged and closed captioning has been put onto it. And I'm sure it's unnecessary, but just in the spirit of this being an informative and stimulating session, I would just ask that we all engage with each other and with the panelists in a very respectful manner, and that we acknowledge that we all come to this with different experiences and different perspectives. And I really hope that we can just share in that spirit tonight. I'd like to start by introducing our panelists. Associate Professor Meredith Blake has taught and researched in health law and criminal law and health policy for over 20 years in the UK and Western Australia. She's the author of the book Australian Health Law with Professor Sonia Allen, and she is the recipient of several grants on a number of different health projects. Dr. Murray Wesson is Senior Lecturer and Associate Dean of Students at the UWA Law School, where he teaches and researches in constitutional and human rights law. Julie Falk, unfortunately, is no longer able to join us this evening, but we all just would like to wish her well as she begins her period of parental leave. So unfortunately, we're going to be tackling administrative law questions ourselves, I think. Faced with the challenge to some COVID restrictions in New Zealand last year, the New Zealand High Court stated in the case of Borrowdale that even in times of emergency, even when the merits of the government response are not widely contested, the rule of law matters. And the panel tonight really gives us a chance to, I think, dig into some really important issues in relation to the exercise of governmental emergency powers and what this means for individuals, for democracy and for the rule of law. This is not the first time that Australia has seen such exceptional measures, as much as for many of us it feels like it must be. I mean, even this week, many of you might have seen there was an article on the ABC that was reflecting on the similarity of the response to COVID-19 with some of the measures that were put in place to tackle the 1919 Spanish flu, with historian Dr. Charlie Ward quoting from a Northern Territory news article as follows: "The hotels are quiet as a church. The streets are devoid of the usual moving mass of humanity. Shops and businesses, places generally look tame and silent, and schools, hotels, churches and theatres are closed." So what I really want for this session tonight is for us to focus on what powers are legal and justifiable in the face of the crisis that we've been experiencing, whether that be snap lockdowns, mask wearing, COVID safe app scanning, travel bans, what have you. What checks and balances exist across the Federation, and how robust are these in the context of a crisis like this pandemic? What rights protections does Australia's constitutional and legislative framework provide? And also, I think it'll give us a chance to look at some of the legal challenges that have been mounted to some of these restrictions as we develop through some of the questioning. Now, there are a number of examples that I think we could talk about this evening to really help us flesh out this discussion. We could talk about the WA hard border and the online G2G application process for entry, which has been put in place as part of the controlled border arrangement. We can talk about the extensive use of delegated legislation and the number of these instruments that have been exempt from parliamentary oversight, something that's recently been examined by the Senate Standing Committee for the Scrutiny of Delegated Legislation. We can talk about the imposition of lockdowns. I think one of the most controversial, arguably, was the snap lockdown of the state housing towers in Melbourne last year, and the investigation that then followed by the Victorian Ombudsman, Deborah Glass. And even more recently, in WA at least, the new COVID vaccine mandates, which have seen this announcement of phased vaccination requirements, which will come into play in coming months for a large suite of occupations. And I'm just really looking forward to hearing your questions as well as hearing the insight of our panellists. I should just start by saying that our panellists, Meredith and Murray, are both academics with legal training. They're not responsible for the design or implementation of any of the COVID-19 governmental responses. And really, they are just here to help us talk about and unpack the legal context of these measures. We have received in advance of tonight's seminar a number of employment-focused and kind of, small business or business-focused questions. And due to the expertise of our panel, we really are going to focus on questions that they're best placed to answer. And we can address employment matters really at a very general level only. But I would want to note, and I will provide some further details for Rebecca to put on the website for this seminar, where attendees can find out more from organisations such as the Fair Work Ombudsman, Circle Green Community Legal, or WageLine, which does have a lot of information in relation to COVID-19 and restrictions, particularly in the employment context. Look, to get the discussion going, what I thought would be a good start would be to look at some of the questions that we've received in advance of tonight's seminar, which I can start by putting to the panellists to start some discussion. And then after about half an hour, we'll see how we go with those. We're then going to open the floor to some open Q&A. So what I'd probably like us to start with, we've got a number of questions looking at the declarations around Australia of states of emergency in different forms. And I guess, Meredith, you're probably best placed to start in really talking to the audience about, what is a state of emergency? How long does it last? Can it continue in a situation like in Western Australia where we don't have any COVID active cases in the community?
Thanks, Sarah. I must say I feel very special to be sitting between two constitutional lawyers. So I've got two pieces of legislation here sitting on my lap for a reason. They're quite complicated, particularly the Public Health Act. And I know there are some lawyers out there who might have a full understanding of the way that statutory frameworks operate. But what we've got is, I think we've got to understand at the outset, we've got federal frameworks and state frameworks. And the federal framework that is relevant to the state of emergency is the biosecurity legislation, and that enables what happened last March was that the Governor-General declared a human biosecurity emergency, and what that then means is that under that Act, the Federal Minister for Health can make certain decisions, and those decisions have included banning cruise ships from coming to Australia. They've included the various travel bans. Really, that gained most attention when the federal government banned Australian citizens returning from India. So that was a federal power that was exercised under that biosecurity legislation. I think it's 477, section 477. And one of the things that people ask is how can this happen? And the reason why is that this power has been passed by Parliament. It's obviously a pretty big act. Section 477 is, you know, hundreds of sections in. So that's the federal side of things. The state side of things, we have two relevant pieces of legislation. There's the Public Health Act, which, as you can see, is a pretty hefty piece of legislation. And there is the Emergency Management Act. So these are both passed by state parliament. And that, how it's worked here in Western Australia is that we've actually got two concurrent states of emergency happening. One is a public health emergency, and that's under the Public Health Act. And so the minister can make, the health minister can declare that a public health emergency is happening. And, you know, there's a definition of what that means under the legislation, but essentially means a situation or an event has arisen in which there is threats to human life and health, and it on a wide scale basis, because we've got to remember we're talking about public health. This is not just affecting a few people, it's affecting huge sections of the population. And that then means that as a result of that, as the legislation says, extraordinary measures can be taken. And that, as a result of the powers that are triggered by that declaration, that means that the Chief Health Officer of Western Australia can make directions, and those directions have largely been, trawling through them as I have in preparation, it largely pertain to testing and to directions around access to workplaces. And I can talk more about the vaccine mandates in relation to that. And then the second state of emergency is that declared under the Emergency Management Act, and that's by the Emergency Services Officer, who at the time when the pandemic started, which seems so long ago now, back in March, was Fran Logan. And so that is a state of emergency was declared. And again, what that triggers is a range of extraordinary powers, which means that the Commissioner of Police, Chris Dawson, has been able to issue directions across a really wide range of areas, including quarantine, movement, stay at home, travel restrictions, mask mandates, and border controls. So that's where the powers for the state of emergency arise. And the thing is, I guess for you to understand, is that these are acts that have been passed by a Commonwealth Parliament and by the State Parliament, and they include these provisions which are triggered by that declaration. And the two operate alongside each other. So there's a specific provision in the Public Health Act saying nothing that can happen under this Act affects the operation of a state of emergency that's declared under the Emergency Management Act. So I can't remember if that was all that you asked me, Sarah. I've printed out the copy of the question.
No, but that's right. I guess, you know, you have answered exactly what because I was then going to ask you how that overlaps with sort of the lockdown or mask mandates, which you've then mentioned kind of these directions. But I might ask Murray. We did have quite a few questions about. I might come back to questions afterwards, so I'll put you on my list.
But before I just to clarify though that these states of emergency can only last for 14 days, so they need to be reissued, if you like, after 14 days, and that's happened on a continual basis since the start of the pandemic. So under the legislation, there is that capacity to reissue those states of emergency, although there's obviously a very limited time frame for which they can operate.
Yeah. And so that one of the questions we had was how those could keep being reissued if there weren't active cases in the community.
Yeah, I think the answer to that has actually been addressed in a couple of cases that have come out of the eastern states, and that is that it's all about risk, right? So it's not necessarily whether there is a lot of COVID in the community. It's really about risk management. So the idea is these, no one's going to question their fairly extraordinary steps being taken to manage that risk. And so the actual reality or not of what COVID you're living with doesn't necessarily mean that state of emergency has ended. And indeed, it might be argued that it is the measures that have been introduced through the state of emergency that have resulted in the very low COVID numbers. So that's essentially the picture. Yeah.
We did have quite a few questions, Murray, about how, in understanding this of the Biosecurity Act and the WA response, like where does the Commonwealth Constitution fit in within that hierarchy?
Sure. So the Constitution is the supreme law in Australia. And what that means is that legislation enacted by the Commonwealth needs to be supported by the Constitution. So there needs to be a head of lawmaking power in the Constitution, which allows the Commonwealth to enact, for example, the Biosecurity Act. If one looks at the Biosecurity Act, it in fact lists a few heads of power that the Commonwealth regards as supporting that act, for example, the quarantine power or the external affairs power. And what that means is that, well, it means two things. Firstly, that the legislation needs to be supported by the Commonwealth Constitution, but then also any public health measures imposed in terms of the Biosecurity Act also need to be authorised by the Biosecurity Act itself. So any measures that are taken in terms of the legislation need to be authorised or supported by the legislation. If we look then at the state legislation that Meredith outlined, the authority to enact that legislation is derived from the WA Constitution. The WA Constitution, or the WA Parliament, has far broader lawmaking powers than the Commonwealth Parliament, and that they don't need to show that the legislation is supported by a particular head of power. If there is inconsistency, though, between Commonwealth and state legislation, then under Section 109 of the Constitution, the Commonwealth legislation will take priority. As it happens, though, the Commonwealth legislation has been specifically drafted so that it operates concurrently with state legislation. So in other words, we have, where we are in WA, we're subject both to the Biosecurity Act and to the legislation that Meredith has outlined. And measures can be introduced in terms of all three of those statutes that apply to us. One exception to that, and I think it's a good indication of just how far-reaching these powers are under the legislation, is under the Biosecurity Act, under Section 477, or rather 4781. The Federal Health Minister can give any direction to any person that they regard as necessary to prevent the or control the emergence of human disease. And further, that can override any law in Australia, with the exception of the Constitution itself. But the Federal Minister does have the authority under the Biosecurity Act to make determinations that override state law. But for the most part, the legislation operates concurrently.
Now that's really helpful, I think, just to give us kind of a starting point for the discussion. I mean, one of the other questions that might be good to really kickstart the discussion as well is, in thinking about the constitutional framework, what constitutional rights individuals have in Australia?
Well, that could be quite a short answer, actually, because we are unusual in Australia. We're the only liberal democracy that doesn't have a federal Bill of Rights. If one looks to the Commonwealth Constitution, we find very few rights or rights-like provisions in that constitution. So, for example, there's no express right to freedom of expression in the Commonwealth Constitution, but the High Court has found there's an implied freedom of political communication, which operates rather like a right to free political communication. But the rights provisions that we find in the Commonwealth Constitution are sparse. Now, there's also no doubt, though, that many of the lockdown measures that have been introduced have imposed quite extraordinary restrictions on human rights, requiring people not to leave their homes, not to freely associate, not to exercise the many freedoms that we're used to exercising. These are extraordinary measures. Of course, they also further a human right, which is the right to health, but we can't be blind to the human rights implications of public health measures. Now, there have been some attempts to sort of leverage the very few rights protections in the Commonwealth Constitution to challenge constitutionally some of these restrictions. So there was a case in Victoria where an unsuccessful attempt was made to sort of leverage the implied freedom of political communication as a way of challenging some of the restrictions of freedom of movement that existed in Victoria at that time. And I think even without getting into technicalities, you'd be able to appreciate why that might have been a difficult argument to sustain. You know, with lockdown measures, we're still capable of communicating with one another due to technology and so on. Now, at a state level, and again, as Meredith said at the beginning, in a federation, we always need to be very mindful of distinguishing between state and Commonwealth lawmaking powers. In Western Australia, we don't have human rights legislation. And so what that means is that the measures that have been introduced from time to time can't be tested against human rights standards. The position is a bit different in some of the other states and territories in Australia. So if we look to Victoria, the ACT and Queensland, there is human rights legislation in those jurisdictions. And on occasion, some measures that have been introduced have arguably infringed that legislation. So one good example that Sarah's already alluded to is the lockdown of public housing towers in Melbourne, 9 public housing towers. And there was a very sudden lockdown. It wasn't clearly supported by health advice. There's very little notice given. The restrictions were quite extreme. And the Victorian Ombudsman did find that there'd been a violation of the rights of the several thousand people who resided in those towers. They recommended that an apology be made by the state government, and the state government declined to accept that recommendation. And that, in fact, also gives us an indication that sometimes the powers that are given under the human rights legislation in these states and territories are fairly limited. So the Victorian Ombudsman, for example, can investigate maladministration relating to these human rights standards, but they don't have coercive powers. They can make recommendations. And similarly, the courts in these jurisdictions can declare that legislation is inconsistent with human rights, but they can't set it aside or invalidate it. And really what that reflects, just to go back to the question that Sarah posed at the beginning, is that our sort of constitutional tradition in Australia, when it comes to abuse of power, when it comes to infringement of rights, is involves relying on the political process. Unlike the United States or Germany and South Africa, we don't look to the courts very often to resolve these issues. We instead look to parliaments. And so I think we will find ourselves quite repeatedly this evening saying, well, you know, there might be a human rights issue, for example, but the remedy for that is in the political process. It's not necessarily through a judicial process.
Yeah, no, absolutely. And I think one of the things something that's often been said in the last 12 months especially is that often when these matters do come to before the courts, they're very deferential to public health. And I mean, Meredith, I don't know if you want to reflect on that in terms of how it might be that we balance sort of civil rights against public health, and does the public health evidence justify the extremity of some of these responses?
It's how many times over this last year and a half have we heard the health advice, the health advice? I think one of the interesting developments that has occurred in the last couple of weeks is that the Victoria Privacy Commissioner has required the publication of the details of the health advice that supported one of the shorter lockdowns several months ago now in Victoria. And you may or may not be aware that Victoria is currently looking to pass legislation, and it looks like it probably will pass, which will change the way that state of emergencies operate so that it is instead becomes a pandemic response as such that is controlled by the politicians. But one of the reasons why that secured the support of the crossbenchers is because there is inbuilt into this new legislation guarantees of transparency and advice, an advisory board and a review board, which is made up of human rights experts as well as health experts. So I think what's really evident from the challenges that have been have made it to the courts. So there've been several. Sarah's, you've mentioned the one around or the inquiry into the lockdown of the housing towers, but there's also been a couple of cases that have concerned challenges around the curfews and the geographical curtailment of movement, and a really interesting case from New South Wales which involved a challenge to the decision to ban a Black Lives Matter protest. And it's evident from all of those cases that the evidence of epidemiologists is being really significantly weighted in the court's review of the legality of the measures. And maybe something to be said about public health. And this, you may or may not be aware that a recent challenge in New South Wales to the vaccination requirement for certain sectors of the workforce over there was handed down a couple of weeks ago, and it was unsuccessful. And one of the reasons why is that the court looked at the supporting legislation behind these measures. It's the public health legislation. They call it the public health and wellbeing legislation in Victoria. And they said the whole rationale behind these pieces of legislation is not really about preserving individual rights. The whole function of it is to focus on the collective health of the community. And so to try and make an argument, for example, and Sarah and Murray will know more about this, but an argument that it's in breach of the principle of legality, for example, which is a kind of a presumption that anything that's introduced isn't going to interfere with our common law rights, doesn't really have much purchase when the measures that have been introduced are through a piece of legislation which is designed to prioritise community health, and therefore in that process is inevitably going to interfere with individual freedoms. So I think it's really important to recognise that that's the lens through which these challenges have been decided, very much through, this is about a public health crisis, and in that situation, the powers that have been enlivened through the declarations of state of emergency or just general powers as we see in New South Wales, they allow for this and giving, significant weight to evidence that the epidemiologists have to give. I said the one about the Black Lives Matter protest was really interesting because that was a protest that was supposed to occur in July last year. There had been already a Black Lives Matter protest in Sydney in the previous month. And the evidence from the rates of COVID transmission from that earlier protest in June was that there really hadn't been any sort of a spike as a consequence of that protest. But what led to the result that the ban on the protest was legal was that the court said the evidence of the epidemiologists is that the situation has changed now, and that's because of the COVID outbreak in Victoria. And so they said, we can't look at it as if it was June. It's now July. Things have changed, and you might all be wearing masks when you protest, but you're going to be doing this in the middle of the CBD, mixing with workers and other people who are not wearing masks, because at that point there wasn't any general mask mandate. So it was interesting how the epidemiological evidence factored in there to demonstrate the difference between, within 1 month.
And does that work the other way? I mean, because we've had quite a few questions saying, well, to what extent are interstate border closures valid in the face of available vaccines? Or do you say if the risk changes? I mean, I don't know, Murray, if you want to maybe touch on that.
Yeah, we had, of course, the litigious Clive Palmer challenged our hard border arrangements. So sometimes in the law school, we could teach a whole unit on Clive Palmer's court challenges. This needs to be kept separate from the more recent challenge to legislation relating to his contractual claim. But yeah, so WA's had a hard border arrangements from early on in the pandemic. Initially closed to all Australian states and territories, and there's currently a more sort of moderated approach. And Clive Palmer challenged that border arrangement, and the argument that he made was that it conflicts with Section 92 of the Constitution, which, among other things, guarantees freedom of intercourse between the states. So on the face of it, that would seem to be a very compelling argument that if the Constitution guarantees freedom of intercourse, freedom of movement between the states, then the sort of measures that we've had in Western Australia restricting freedom of movement would seem to be unconstitutional. But there is High Court authority saying that you can restrict freedom of movement if the restriction is proportionate to a legitimate aim. So it's a sort of similar approach to what we see with some of the human rights standards that Meredith was discussing. And the High Court, the Federal Court made certain findings of fact that the High Court considered. And what they found at that stage was that the hard border was justified because in terms of these findings of fact, even a single COVID case in Western Australia could result in what they termed uncontrollable community spread of the virus and potentially catastrophic consequences, and accordingly a precautionary approach should be taken. Now, in that same judgment, the High Court also noted that at that stage there was no known vaccine. And of course, since then, things have changed in that we do now have several vaccines, and more than half the state, getting on to 60%, is fully vaccinated. And what that potentially means is that that finding could change, or rather, let me put it differently, it might be more difficult now to maintain the constitutionality of WA's hard border as the rate of vaccination increases, because it becomes more and more difficult to sustain the claim that even a single case of COVID in the community is potentially catastrophic. Now, I mean, that's not to say that our border arrangements will be challenged in court. That requires someone who's well-resourced and motivated. Of course, that has been Clive Palmer in the case, but whether he's minded to bring another challenge, I'm not sure. It is also, interestingly, I think it would be open to the Commonwealth Parliament to enact legislation requiring freedom of movement in Australia between the states and territories. It is perhaps subject to certain requirements, but I think, given the imminence of a federal election, that's probably highly unlikely, given that these border arrangements have enjoyed public support in Western Australia. But I think, just to go back to the question, it's a great question, because I think what it recognises is that measures that might be justified at one stage of the pandemic can cease to be justified later, and measures that might be lawful at one stage of the pandemic might not be lawful at another stage. And so certainly at the time when the border arrangements were challenged, the High Court didn't, I don't think, had great difficulty in dismissing that challenge. But as our rate of vaccination increases, then the border arrangement becomes more constitutionally vulnerable.
And then I guess these questions all flip on top of each other, because then you say, well, if we then take vaccine mandates, which obviously then might impact on the constitutionality of hard borders, are the vaccine mandates themselves constitutional? And I guess, and also, I guess we've also had quite a few questions just about how they're enforceable. Can you conscientiously object? Are there exemptions? So I don't know if you want to sort of fight over who wants to tackle some of those issues first.
Well, I can talk, and then maybe you can address the constitutionality of it. The term mandates is an interesting term. So what we're seeing is we're seeing directions that have been issued in the way that I indicated through those powers under the public health legislation, which are essentially focusing on people needing to show proof of vaccination in order to access their workplaces. And we know that this is the number of workplaces, the list of those has increased quite dramatically. That list increased last week. I should add, though, that directions in relation to those announcements last week haven't actually been made yet. So those directions haven't been issued. It's just a new vaccination policy that's been released under another piece of legislation called the Health Services Act. So at the moment, that's an indication of where the government is going to go, but there's no formal direction, and there's no mandate until the direction is issued, because it's the direction that has the mandating quality to it, and which brings it the ability to issue fines or to actually have let's say a bite to it. So you know, something referring to what Murray said, you know, you can bring these things into courts, but you know, whether or not asserting your human rights actually has any demonstrable effect is not necessarily going to happen. So I think that what we need to I suppose address is whether or not introducing vaccination as essentially a condition of employment in that particular sector is something that is lawful. And again, leaving the constitutional side to Murray, there have been this challenge in New South Wales, where the New South Wales government indicated that and made it mandatory for certain areas, certain LGAs to be vaccinated in order to travel to their place of work. And that was unsuccessful. And one of the reasons why, as I've indicated, was that the view of the court was that this was, you know, reasonably necessary. And one thing I think that you should be aware of is that when these challenges to these sorts of directions occur, the court can't make a new decision. The court can't make a decision as to whether or not this was the right thing to do. So the court's review is not of the merits of the decision, it's of the legality of it. So whether or not that the person making that decision, whether in that case, the Hazard case, it was the health minister, is within the lawful boundaries of the power that he or she has been given. So that's not, the court can't come in and say, well, this was the right direction to make. The court comes in and says, well, did that particular person who has that power exercise that lawfully? Okay, and so the issue of whether it's reasonably necessary is not whether it's right or wrong, it's whether it was within the boundaries of the power that was granted. And so the court said, well, yes, it was. And there's another claim that was addressed in that case, which is specifically an issue to do with consent. And it was the argument that if people are required to get vaccinations in order to maintain their employment status in that particular workplace, then they haven't truly consented to the vaccination. So this is an issue of voluntariness. So in order for a consent to medical treatment or medical therapy, which vaccines are recognised as, then the person needs to have decisional capacity. They need to have some information about the nature of the treatment or therapy, and they need to make that decision voluntarily. And the court found that this requirement for as a condition of work was not an example of coercion. And I can explain why that is consistent with authority around medical decision making. But I'll leave it to Murray to address the constitutional.
On the constitution,
Come back to that
I mean,
point.
really,
Yeah.
I think there may be some questions about that. So,
Yeah.
So as far as vaccine mandates and constitutions are concerned, it really goes back to the point that was made earlier in this discussion that Australian parliaments have broad lawmaking powers. So if we look, again, being careful to separate the Commonwealth Parliament and state parliaments, if we look at the Commonwealth Parliament, there have been some claims that there are provisions of the Commonwealth Constitution that might impede the introduction of a vaccine mandate. So, for example, there's been some discussion, mainly on Facebook, it has to be said, that Section 5123A.
No discussion on Facebook. You're not allowed to have discussion.
Okay, well, I've seen Facebook posts making this particular assertion that this provision of the Constitution would prevent a vaccine mandate, and it refers to civil conscription. But really what that's directed at is the conscription of medical professionals to work for the Commonwealth. It doesn't, I think, stand in the way of a vaccine mandate. The other section is Section 116, which concerns freedom of religion. And there may be, or there are some groups such as Christian Scientists who may have religious objections to vaccines. I mean, vaccine mandates are not entirely new. For example, to access certain welfare benefits has, for a while now in Australia, required proof of vaccination. And there have sometimes been religious exemptions in relation to, for example, Christian Scientists. So that's a fairly small group of just over 1,000 in the last census, I believe. But this provision relating to free exercise of religion has also historically been interpreted narrowly by the High Court. But actually, the far more important observation here is that most vaccine mandates will be introduced by state legislatures. And so, for example, the vaccine mandate relating to people working in residential aged care, that was agreed by the National Cabinet, but the actual implementation of it is through state parliaments. And state parliaments, as I said earlier, have what we call sometimes plenary, essentially very broad lawmaking powers that are not constricted in the same way that we find with the Commonwealth Parliament. And so I think it's very difficult to sustain the claim that there's any kind of significant constitutional obstacle to the introduction of vaccine mandates. But that doesn't mean, and Sarah and I discussed this earlier, if we say something's lawful, it doesn't mean you have to agree with it, right? So what we're doing on this panel is we're trying to explain what the lawmaking powers are that our different levels of government have. And it may be that you certainly can imagine vaccine mandates that I regard as problematic. So, for example, a vaccine mandate that conditioning access to healthcare upon a vaccine mandate, public healthcare, I think would be problematic, or conditioning access to education. So, what I'm saying is that I can't identify any significant constitutional obstacles to vaccine mandates, but that's not meant to be a conversation ender. What that's meant to do is just say something about the lawmaking powers that our different parliaments have in the Australian Federation.
Maybe before we open up, just maybe it might be helpful, Meredith, if you can just talk through kind of the exemptions and how it is that the exemptions operate to what once this mandate does become, enforceable.
So the exemptions, it's interesting. So in addition to the flu jab, there's obviously, prior to that, you may probably aware, vaccination policies for small children in daycare and kindergarten. It's called the no jab, no play policy, which has been, is an example really of a I suppose, a carrot rather than a stick approach. We talk about this in public health, where if this child can't produce evidence of up-to-date vaccination policy, then at a federal level, they're not entitled to certain social security benefits, and at a state level, where there's been an aligned policy introduced, they can't actually access the service at all, okay? So in relation to that particular policy, the exemptions are wider than the exemptions that we see for the flu policy and for the proposed COVID-19 policy. I say proposed in the sense of the wider range of workplaces that was indicated last week. Of course, there are already directions in relation to people who work in quarantine and who work in health, front-facing health staff. And that really is about previous anaphylactic reactions to vaccines and to people who are in very in certain immunocompromised situations which have been shown to be not compatible or with receiving the particular vaccine. So, for example, conscientious objection is not a ground for an exemption. A certain religious belief is not a ground for an exemption. So the grounds for exemptions in relation to flu and COVID-19 vaccinations are actually really quite narrow, and I'm comparing them to the exemptions in relation to children. So, and there are different reasons for that, but I mean, I guess just the short answer is they are really narrow, the exemptions.
You wanted a vaccine, is that right? Because it's still an experimental trial time. It's not even going to finish its trial until 2023, and the whole world is under this experiment. So how can you actually call it a vaccine on I can't handle it? I don't think it's named vaccine until it's actually full state.
So the COVID vaccines went through experimental trials prior to their approval.
Just let Meredith answer the question, then we can have another question after that. Yeah. Just let Meredith answer the question, and then we can have another question. And this gentleman here has been waiting a long time too, so I haven't forgotten you.
So the Therapeutic Goods Administration is the national body that approves vaccines. And you may not agree, but it has a reputation as being probably the most robust process in the world. And prior to the approval of the vaccines, there were trials that were run. And when they were the basis upon which the TGA approves vaccines is on always a risk and benefit analysis. And so once that approval came through, it is not, as you say, a final approval, okay? That's clear. Why isn't it a final approval? Well, it's not a final approval because the TGA wants to keep collecting data from about the vaccine. And that data is largely is to do with its long-term effectiveness. So it's effectiveness. And so really what they want this data to do is to inform decisions about boosters and further vaccines and what's needed. So there were trials, and that was prior to the approval. The approval that's been given is not the final approval, but they asked, and this is to enable them to collect this data to get further insights into its longer term effectiveness. So that's how the process has worked.
Would you like to ask your question? Because you've been waiting so patiently. Yeah. And then
back to
Just wait for the mic.
with respect to the, for example, Biosecurity Act and the WHO Act, how many people are actually involved in deciding the state of emergency to exist, and especially with the 14-day reviews, how many people have that decision capability?
That's a really good question, because it's not a decision that goes through a parliamentary approval process, right? So Parliament doesn't sit down and go, yes, we approve the next one and we approve the next one. Under the legislation, before the state of emergency is announced and in relation to any renewals, the Minister for Health under the public health legislation and the Emergency Services Minister under the emergency management legislation is required, so it's not a should, it's a must, receive advice from a relevant committee, so emergency management committee or the in relation to the Public Health Act, a similar sort of committee, and must receive, in the case of the Public Health Act, advice from the Chief Health Officer that this is required. So it's not, and this is the issue around, you know, that we realise in the sorts of decisions that have been made. These are executive decisions which aren't going through full parliamentary approval, but that's because they're linked to state of emergencies, which indicates that there is, you know, or reflects the belief that there is significant threat to public health and safety. So does that answer your question?
I don't know, like, is it a big group or is it a collection of 5 people?
It wouldn't be a huge group. No. If a purposively approved committee that has itself gone through parliamentary processes. So the people on that committee it's a parliamentary committee, but they are there to advise the relevant minister of the need for the declaration of the state of emergency.
We have 90 people online. They're saying that they can't hear the questions, so I'm just letting you know when I pass you the mic, please speak as loudly as you can, and if we can repeat the questions as well. We have one online. Australia has ratified and is party to various international human rights treaties. Could one challenge measures based on its obligations under those in the absence of a constitutional Bill of Rights?
I think I can answer that question. So Australia has ratified the key human rights treaties. That's absolutely right. But just ratifying a treaty does not make it part of Australian law. So it's an undertaking that Australia gives the international community that it will abide by the human rights commitments in those treaties. But even if the treaty is ratified, it doesn't enable someone to approach an Australian court arguing that a law is invalid because it conflicts with a provision in the treaty. And one result of that is that we do find a whole range of human rights standards that Australia has ratified that bind with international law, but they're not enforceable by Australian courts. Good example has to do with, as Meredith mentioned earlier, there was a travel ban on citizens returning from India. As well as that, the quarantine measures that we've had have restricted the return of citizens to Australia. In international law, we do find a right for citizens to return, a right of abode. And certainly the travel ban relating to India, I think, breached that right. But the point is that it's not part of Australian domestic law. And so that particular statute couldn't be challenged for non-compliance with that human rights standard. Because unless it's incorporated by the Australian Parliament, one of the Australian parliaments, it doesn't form part of our legal system.
Can I add in? Yeah. So Jeffrey Robertson, who's a very famous QC human rights lawyer, is in fact representing a group of Australians who have lodged a claim under the treaty that Murray's referring to, the International Covenant on Civil and Political Rights. And that goes to the Human Rights Committee created under that convention And that claim is in relation to essentially the caps on returned travellers, and making an argument that that is a violation of the ICCPR. And that has in fact been declared by the Human Rights Committee in Geneva as admissible, which means then that they can go on to hear the merits of that claim, but that's unlikely to happen.
And also, just to add to what Meredith has said, Australia has lost cases in the Human Rights Committee before
And
in relation to asylum policy, for example, and simply ignored the decision.
them.
So, you know, sometimes they've been implemented, sometimes they haven't. So those decisions, even if the Human Rights Committee in Geneva says, well, this is a violation of international covenant on civil and political rights, it's a bit, you know, it's a recommendation that the Australian government doesn't need to act on.
Yeah, and refugee examples we were just simply ignored.
It can put political pressure though. I mean, and there have been instances where the pressure can lead to change, but it certainly doesn't happen very quickly if it does.
So pretty much you're saying that it doesn't really matter, sorry,
No, just speak louder.
it doesn't really matter what people want. The government's law or legislation is going to override that anyway.
Well, what the
That's
people,
pretty much what you're saying.
no, I'm not saying that at all. To go back to what you said, I mean, our parliaments are elected, and from those parliaments, our governments are formed. So they take the view they have a mandate from the public. And some of these policies that perhaps raise human rights issues that we've been discussing have in fact enjoyed very high levels of public support in Western Australia, such as our hard border. One only has to look at the last election to see the overwhelming mandate that the current government received. So the view of the state government would be actually, we do have public support, we do have a mandate that in fact is perhaps more of a mandate than the Human Rights Committee in Geneva. So in the past, when Australia has rejected decisions of UN committees, they sometimes said, for example, in the space of asylum, well, the Australian people don't want to be lectured to by the United Nations. So, you know, there are different ways of supposing, there are different ways of determining what the people want. I think, and generally I'd be supportive of decisions of the Human Rights Committee being implemented. But I don't think one can say that necessarily follows from the view of what the Australian people want.
Doesn't that really speak to the arrogance of the government, ignoring what a large proportion of the people want now?
I fear I'm being dragged from my constitutional territory to other discussions. So I'll restrict myself to saying what the
My
Constitution says.
interpretation of what you delivered is that it doesn't matter if we don't want what the government dishes out, and to the point where they can go to a Human Rights Commission and have something set against them, and they just ignore it. So that shows us as the people that the government will ignore us even if our claims are incredibly relevant.
But it also, we've had other questions that have said, well, if we look at the legal situation and say that, look, these are lawful determinations, but there is a level of discontent about what that means on a rights level. One of the questions that's been put, let me just finish. One of the questions that's been put is whether we need to investigate greater provision for rights within Australia. So do we need a Bill of Rights? Do we need to look at statutory charters across the Federation? You know, and I don't know, Murray, whether you want to sort of reflect on that, or whether that's something we can move on to think about.
Yeah, I think there's so many questions.
Yeah.
I think what we've tried to do is to set out the lawmaking powers that exist, but also to point to where there are gaps in accountability, and I think we've tried to do that all the way through. But let's hear some more questions from the floor.
Please, go for it.
Thank you. Perhaps you could just talk through that decision from New South Wales where not requiring consent to receive vaccines now in the provision.
No, well, that's not what the court said. And there's another case as well, actually, that comes from New South Wales. So that was in New South Wales. There's a case from Victoria as well, which doesn't involve the COVID vaccine, but involves a flu jab that a worker in a childcare workplace which she refused to get, and then her employment was terminated, and so she took that to the Fair Work Commission. So, so one decision that I'm aware of in relation to what we call mandated vaccines is that one, which is a Fair Work Commission, which is not a court as such, and the other one is this the claims brought by people in New South Wales, principally against Brad Hazzard, who's the Health Minister. Now, in both of those cases, the people bringing the claims did make as a ground of their argument, their claim, that this was effectively a situation in which they were being coerced, right, into giving their consent. And in both cases, the court was really, the court and the commission talked about the common law authority that we have around what is a valid consent to treatment. And the issue of coercion is obviously around voluntariness. And there are different ways in which a person's consent can be regarded as involuntary. For example, if fraud's involved, or if there's undue influence. And coercion is a ground to render a consent as invalid. But in both situations, the decision by the Fair Work Commission and the decision by the Victorian Supreme Court, the view was that when the common law authority around coercion is really about the situation where a patient has been coerced by the person giving the treatment into giving their consent. It's not about a more general policy around what is essentially a condition of work. So the way that the Fair Work Commission and the court interpreted this is as a condition of employment. And I will quote to you from the Good Start Early Learning case, I've got it here, said she may feel threatened that she must provide her consent or face termination, but that's not the same as the threat of being forcibly vaccinated. So the court and the commission drew a distinction between being threatened with forcible vaccination. They said, this is not what is happening. It is their interpretation. So this is, I'm just interpreting what these cases are saying, is that this is a condition of employment. And the person in question still, it has the choice. They can get vaccinated or not. And in that respect, the condition of employment might be similar, for example, to having to undergo a medical prior to employment. So that's the way that this is being approached. And I must say that that interpretation, in my quite extensive knowledge around consent to medical treatment, is in line with the authorities that we have.
Just wait 1 minute. And I will repeat your question because I understand that our Zoom attendees are just finding it hard to hear some of the questions. So,
hello. As an employer, I've gone out to insurance agencies and underwriters and asked about this mandate, which I don't necessarily support. And there is an instrument of legislation that's been released in New South Wales that stipulates that employers are responsible for long-term side effects of the vaccine. And it's interesting because they have a different set of rules in terms of premiums. So they're ruled by ICARE and the premium set on the industry, right? But in Western Australia, South Australia, your premiums are set by your claims history. And so I've tested this in each state, because I've got employees in each state. And the issue is that as an employer, if there's a mandate for a vaccine as a condition of employment, the employers have the liability, long-term liability for any adverse reaction to the vaccine.
So the question that we've had just for our Zoom attendees is whether employers may be liable for long-term adverse reactions to vaccines and how that might intersect with potential insurance premiums or insurance obligations as well.
It's true. I've gone out to the underwriters and I've actually got the information from the underwriters saying they are covered under your work.
So let's see. I don't know, Meredith, whether you have a response to that or whether it's too insurance focused.
Yeah, I'm not an insurance lawyer, so I come in as an expert on consent.
What about the legislative instrument released in New South Wales where they've actually stipulated inside that New South Wales employers are responsible for long-term. I'm aware that this issue around of compensation and compensation more generally, okay, so there's not, compensation hasn't only arisen in that context, it's arisen in broader contexts as well. And there is, as far as I'm aware, a degree of uncertainty prevailing as to how that is to be approached in those different contexts. I'll give you an example of where there is a policy. So in the UK, for example, there is essentially a compensation fund that's been created so that people who do suffer adverse reactions are able, through that government scheme, to claim compensation, right? We haven't gone so far as to adopt something of that nature here. In terms of the particular New South Wales position, I'm not really on a position to comment on that because I haven't seen it. But clearly there are issues that arise in relation to workplace mandation, and that includes not only compensation, it involves questions around production of the evidence of the vaccination itself, because that of course raises issues around privacy of healthcare information. There's a complexity of issues that are there that haven't yet been resolved. So I would only be speculating from a position of quite, of ignorance at this point to say anything about that. I've actually got confirmation from significant underwriters that we are liable for long.
Right.
Well, as I said, as I mentioned earlier, there's also some websites which I will give to Rebecca that she can put on, which do have a number of FAQs for employers, both in relation to state matters and federal matters. Do you want to take a question from Zoom, Rebecca?
Yeah, so we have a question on S92, I assume it's section 92, the Constitution. Okay. What significance has the High Court attributed to the word absolutely in S92 of the Constitution? How does the literal interpretation of the word absolutely sit with the court's adoption of reasonable necessity and structured proportionality analyses when assessing compliance with S92? For example, in relation to the constitutionality of state border restrictions. Maybe you can explain what that means. And
yeah, I'm happy to explain what it means. And it's really taking us back to a question that was asked earlier. And it has to do with the constitutional challenge to Western Australia's foreign border. The relevant provision of the Constitution says that intercourse between the states should be absolutely free. And on the face of it, that seems to be an absolutist position, which doesn't admit of any restrictions on interstate movement. But the thing is, you can never understand a constitution just by its words alone. You have to understand it. We've had the Constitution since 1901. You have to understand it in light of the case law that's been decided through that entire period up until the present day. And if you look at the Palmer case, what the High Court said there is that you can restrict free movement between the states, but you have to meet this requirement of proportionality. And the specific question there relates to structured proportionality. And that really is just a way of framing the proportionality test. And what it means is that the restriction on free movement can't go further than is required by the objective that you're pursuing. As it happens in Palmer, what the court said was that the objective being pursued, the public health objective, justified the measures at that time. With higher rates of vaccination, those arrangements might become more constitutionally vulnerable.
Thanks, Murray.
First of all, I think the whole issue arising here is underpayment laws. So all these vaccines have been passed underpayments, and there's so many different, medications which are out of payment, which aren't, which are being covered up. Basically, there's a collusion between big tech to cover up all of these different medications. It's been proven since the 1980s. Ivermectin is one of these medications which has been proven in Scotland, so 330 million per dish. It's been proven in New Mexico to be more effective than the vaccine, but none of this has been caused by the mainstream media or any of the search engines. Going forward, we got to look at the statistics that we have.
Can I ask, did you have a question for the panel though, just so that we can kind of get some discussion going from the
According to Ausbank, so a survey of 4,125,440 people surveyed, 43.6% have had adverse side effects.
What's the question?
Less than 2% has been reported to TGA.
And your question relates to concern
How can
around
we stop
the
this
mandating of
vaccine?
vaccines, which you have concerns around their safety.
How can we stop it? Yes, because this is a safety issue. There's already adverse side effects. How can we stop this experimental vaccine?
So the concern for the audience relates to experimental nature of the vaccine and how they can be stopped with concerns about their side effects.
Not use that term experimental. Not experimental. It's like BioNTech Pfizer is fully approved by the FDA by now.
Yeah.
So calling it an experimental drug is only encouraging people that shit.
It's been out for how long?
Let's hear from, before this, just because the Zoom audience isn't able to hear the conversation in the room, I would just ask that Meredith might wish to respond to the question.
Well, I did earlier outline the way that the TGA operates. All I can do is tell you those processes that are undertaken by the TGA that I'm aware of are set out in law. It's a body that's created by the Commonwealth Health Department. It is regarded as being really setting out standards that are the most robust or amongst the most robust in the world. And so there's been trials, there's been approval, and they are no longer in that sense regarded as experimental. So we have just to speak about what's in place in terms of bodies that look at the evidence and weigh up the risks and benefits. We have those bodies in Australia. Whether they're doing what you'd like them to do is not something that I can really comment. I'm just setting out the frameworks that are there.
I think the question was hijacked by the gentleman's objection to lived experience. The question the gentleman asked was, how do we stop it? Are you able to speak in a legal framework to that question? Is there any possibility to pursue how do we can possibly stop or gain some support or momentum or traction behind the push against mandated vaccines? I think that was the original question that got hijacked.
No.
So,
just let Meredith answer.
so if this is what has been happening in the courts where the challenges have occurred, right? So there have been challenges in relation to the mandation of the vaccines in certain workplaces. So we've seen that happen. We've seen how the court and the Fair Work Commission have dealt with the claims by the various people who are making those claims, and that those claims have basically argued that the mandation of the vaccines through the health orders is not lawful because they've been done without legal authority. So that these are orders that have been made outside of the powers that have been given to the minister or the chief health officer or whoever it might be. And I've explained that in order for those claims to be established, the claims need to establish that what those steps that have been taken, whatever they are, so not just mandatory vaccination in workplaces, whether it be the wearing of masks or geographical limits or curfews, are not a reasonably necessary response to the public health crisis. So that's the question legally that's been put to the courts and the commission, and the courts and the commission have determined that the evidence that they have before them, the evidence of epidemiologists, the other evidence that they have, and remembering that it's contextual as well. So what is appropriate for one workplace may not be appropriate for another workplace, okay? And the courts in the two examples that I've given to you have decided that the measures taken by the childcare company and by the health minister in New South Wales in relation to mandating vaccines in certain workplaces did pass the test of being reasonably necessary based on the evidence that was produced before the court. So all I can say is that that's the route to challenging it. But what we are seeing is the exercise of, and we haven't shied away from this, of significant executive powers that have been triggered through this pandemic and the declaration of states of emergency. So that's explaining the legal framework. Okay.
We have
someone back there.
before you get on with the mic.
No, it's okay. Yeah, please, it's okay. And then the gentleman in blue has been waiting very patiently, so I have promised him after you, Rebecca.
Right, no problem. We have a Victorian online saying that there's a proposed legislation in Victoria that's attracted a lot of criticism. Just for a bit of info, the proposed legislation tabled on Tuesday will curtail the Chief Health Officer's powers, giving the Premier authority to declare a pandemic and the Health Minister the role of making public health orders. Now, somebody said that, yeah, it's attracted a lot of criticism for gross overreach and lack of cross-parliamentary checks. Your thoughts and whether this may happen in WA? Is there any view?
Sarah, are you across that recent?
I'm yeah.
I think Meredith mentioned it before.
I did mention
yeah,
it
in the
before.
context of this.
Yeah. Look, it has been criticised because we've heard from the Chief Health Officer very, regularly throughout, and people do. Many people place a lot of trust in that he perceived as and held up as an independent health advice, right? And then through this legislation, it will become a political process. Although the Chief Health Officer is saying he will obviously be giving his advice. The point that I made about that proposed legislation is, firstly, there was the state of emergency legislation, or the powers that allow state of emergency declaration in Victoria are different to what is possible in WA. So in Victoria, it's only possible for there to be a set number of state of emergency declarations, right? So that's not the case in most other jurisdictions. So that was flagged fairly early on, and that prompted the Premier and colleagues to look at alternative legislation. But one of the things that this proposed piece of legislation will do which is currently not evident in the other jurisdictions on the way that states of emergency operate, is there is a guarantee of transparency of decision making. So we will see, well, they will see what the health advice is, and there will be a review committee made up of people who are not only from health, but also human rights experts. And that has been, if you like, the trade-off, I believe, that is getting the crossbenchers to agree, because lack of transparency about what the health advice is and that is underlying the various directions that have been issued has been a really significant issue of concern for people. So that's essentially what that's doing, yeah.
Now, I know you don't have a microphone, but I'm happy to repeat your question.
Thanks for the opportunity. We've got the Biosecurity Act, Section 60, that explicitly gives you facts of a biosecurity control order must be served on a person to require an individual to submit to a PCR test, self-isolation order, or a medical intervention like a vaccine. Biosecurity control order cannot be issued without the individual showing physical symptoms of illness. Only a biosecurity control officer can impose a human biosecurity control order under Section 60 of the Federal Biosecurity Act. Now, I just want to understand how this gets overridden by the state of emergency.
Okay, so the question relates to Section 60, you said, in the Biosecurity Act in relation to a biosecurity control order, and how that can get overridden through a state of emergency.
You want to?
I think it might be more your area than mine, Meredith, but just very briefly, the declaration of a state of emergency triggers extraordinary powers. And so one of those I mentioned earlier is Section 477, if I remember correctly. Health Minister can give any direction to any person if they're regarded as necessary to prevent the spread of human disease. So those extraordinary executive powers, and the one I've just mentioned, as I said too, can override state law, even though it's the determination of a federal minister, only exist during a state of emergency. So they're in a sense activated by the declaration of a state of emergency. And so then the executive is not bound by the provision that you just mentioned. They can make use of these more extraordinary powers that are activated.
Okay, would you mind if I ask another question? So the omnibus bill that they just passed now, would that give them more powers to extend the state of emergency? Well,
I think that's in relation to Victoria, though. I think.
Yeah.
So the Biosecurity Act being a Commonwealth Act, the state of emergency declaration process is separate to that Victoria is seeking to change through this proposed bill. I think that's what you're relating to.
Yeah. So we're talking about this is the proposed legislation that's been put into the Victorian Parliament is the state regime or regulatory regime. The biosecurity is the Commonwealth regime, and as Murray said, most of it's aligned, really. So in the sense of we haven't seen any conflicts between the state and the federal provisions, which would mean that the Commonwealth provision effectively nullifies what the state is saying. Yeah.
Thank you. It's just a comment on the insurance issue.
Oh, yeah.
I suppose the thing about any insurance policy, I mean, in a broad sense, is it's a question of risk allocation. Who pays for a given risk? And if it's the case that a policy decision has been made that the risk is to be borne by insurers who insure the workers' compensation policy insurance, that means that the burden of the risk premium falls on employers generally, so that the burden of that will be paid by all employers who hold policies for workers' compensation insurance across every industry. The alternative is, or one alternative, I suppose, is that the public health system bears the cost, and they bear the cost. Well, we end up getting the cost. Everybody gets the cost through higher taxes. So it's really, I suppose,
a question of what's the most efficient way to collect the payment for the risk of side effects. And we know that side effects of these vaccines are incredibly rare and in the most part very treatable. So I suppose the marginal cost of paying for someone being at risk is very low. So it seems like, to the extent that's a concern, I think it is one which, you know, put your mind at ease.
It doesn't put my mind at
There
ease.
should be a
The legislation that says employers are responsible.
yeah, so that would be employees in a whole.
We will cover.
That would be anybody.
Insurance group.
Yeah, but that would be anybody who holds a policy of work.
Yeah, but see, in New South Wales,
The-
workers' compensation is set by your industry guidelines. Have a
Yeah, that's
percentage,
right. Yeah.
Input based on, but in other states like South Australia and Western Australia, it's purely dependent on.
I'm
the
just
number of
conscious that
claims
our
that
Zoom
you
audience isn't able to hear this conversation. So I'm also conscious that Professor Sagard needs to also wind up tonight's proceedings. And I know that there are many more questions that we haven't been able to get to. But are you happy for me to take a few more questions? Yeah. Okay. Fantastic. Okay. We've got a leave pass to take a few more questions. So I think this.
Would you like to designate 2 questions you'd like to take?
Yes, certainly. Well, I know Cora's been waiting a long time up here, and then this lady down at the front here. Yeah.
Thank you. Probably just a question to Murray, actually. Will Australians start overseas? I'm curious whether you think there's a constitutional right to return. I know you mentioned like the religious right that we have, and if you think there is one way to define it in the constitution.
Okay, so the question is there constitutional right to return? Probably aware the Australian Constitution doesn't actually mention citizenship. So if you do a word search through it, it's not there. What that means is that citizenship is a statutory construct. It's purely a creature of legislation which can be changed. And I suspect, although it's not something I've reflected on a great deal, there is some rather tenuous authority suggesting that there might be an implied constitutional right to return, but it is tenuous. And so I'd be surprised if a court was persuaded that within the text and structure of the Constitution, even though it doesn't explicitly mention citizenship, there's nonetheless this implied right to return. So I suspect, as for much of what we've covered this evening, the solution for Australians stranded overseas is persuading state governments to start to open up their borders, as we're seeing now in New South Wales, and which I personally hope we'll see in Western Australia in the not too distant future.
Yeah, and I mean, I think, and even with an implied right like that, if it was found by a court to exist, it's not likely to be seen as an absolute right. And so I think, you know, like we've seen with you know, other challenges, it's a case of balancing and whether this is proportionate. And I think that would be likely to be a similar way it would be dealt with. Yeah.
My question relates to the permanency, the mandate still under the state of emergency. Also, I think I've understood right by the mandates may recently have been due to the powers of the state of emergency. What if someone who might lose their job now, once the state of emergency is over, do those mandates still apply, or is it possible that people who've lost their jobs can then reapply in the same industry?
Yeah, yeah, you're right.
So the question,
yeah. So the question is about whether or not those mandates still have effect once the state of emergency has finished. The answer to that is, and I think this is one of the questions that was raised prior to the discussions on the ones that we got. So the power to issue those directions, so those extensive executive powers, are triggered by the state of emergency. So once the state of emergency exists no longer, then the authority to make any further directions no longer exists. However, a mandate that has been, or a direction that has been issued while that state of emergency is in place, something like the vaccination requirements would still continue to have effect, right? In terms of whether or not people can apply for their jobs or can or, for example, alternative roles within the organisation are able to be found for people. That's obviously an employment law question, and that's something that, again, is something we don't really know the answer to. But in terms of the validity of the directions, something that's made during the state of emergency will continue to have effect. But something like, for example, mask wearing, the state of emergency has finished, then there can be that's authorising those particular orders, then, you know, then there must be a reversal of that. And that's what's happened, for example, with mask mandates in Western Australia during lockdowns. So then that's reversed and you don't wear the masks anymore. But we don't, obviously, as citizens, trawl through, well, I have been, but don't trawl through all the different directions, the hundreds of directions there are. You just hear it through a media announcement saying you don't have to wear masks anymore, and you go, great, but you don't really dig underneath to find out why that's so. But that's because the justification for that extraordinary measure has now disappeared.
Now, I'm sad to say that we're going to have to close the seminar at this stage, and I'd like to hand over to Shamit to end the proceedings. No, unfortunately, we don't have time for any more questions.
Questions online, will they be replied to me, to my email, which I gave when I registered? We were given an opportunity to write questions that were going to be answered tonight. So
we were going to try to answer them. We've had hundreds.
Okay, so will you respond to me in writing to my email, my answers?
We'll give you details of who to contact to get
my answer.
Yeah, I'm happy to have a chat with you afterwards too.
Yeah.
Yeah.
Thank you. Sorry, can't get through everything.
Unfortunately, yeah, I wish we had a lot more time. We need a whole, of course.
Sure. I'm not sure if this is
No, we've reached the hour, so the electricity gets cut off. Do you want to just...
it's a university.
Yeah, just speak loud, Charlotte. Yeah. Speak loudly, very loudly.
I'm Shamit Sagar. I'm the director of the Public Policy Institute. I'm also a professor at UWA. I'm all the stand between you and whatever you've got planned after this. I'll keep you only for 5 minutes, so I can time you. I'll speak even louder. Thank you very much for coming this evening. It clearly demonstrates that the Institute's determination to promote and inform public policy has a great purpose. I hope we've sated your appetite to some extent, or piqued your interest. There's some publications as you go out where you can find out more about the Institute. Please do so if that is the case. A couple of quick housekeeping things on my mind just to share with you. First of all, can I just thank our chair and our panelists this evening. I think through Sarah and through Meredith and Murray, we've had a genuine crack at the very difficult exam question. One of the things that comes out of the pandemic is this question of dissent. And there's two parts to that. There's dissent about what's going on in Australia, but there's also dissent in relation to the debate. And we have to pay attention to both of those aspects. And I hope you'll agree we've done our very best without necessarily trying to satisfy all the punters all of the time. Can I also thank, before you go, the UWA Law School and the Australian Association of Constitutional Law, who we've collaborated with in order to provide this evening's event. We've previously done some work on COVID. We've branded it around myth busting. We'll be doing some further work in the new year, so please look out for that. It's obviously an area of high public concern and political saliency, so put a marker down for that. And then whilst I've got your attention, can I just sort of plug the Institute shamelessly further? We have further events in our pipeline, look out for them. On the 25th of November, we have an online only event, which is provocatively entitled Women on Top, to do with progression, not just participation in top jobs. We're looking at not just universities, but we're looking at corporate jobs, we're looking at professions, and we're looking at the gender imbalance in Australia, but also similar countries, with a very distinguished panel that will be chaired by Diane Smith-Gander. On the 1st of December, we'll be holding an event at the University Club just over there, dealing with prospects for the global economy. That's a ticketed event, so you have to open your wallet to get in. Please register if you're interested in that. And then in February next year, after the summer lull, we'll be doing a researcher training workshop on how best to work with government with research in the future. Enough said for me. You have got
plans this evening. Please stay behind if you want to chat with our panelists. And to the question around trying to answer the questions, of course, we'll do our very best. But as Rebecca said, we really did have hundreds and hundreds of questions, so it was quite difficult to get round to every single one. But our intent is to try to give as much attention to questions that have been legitimately put. I'll leave it at that. You're very welcome, UWA. Please come again soon when we have further aspects of this conversation to share with you. Thank you.
Right.